A 14-year-old in Pennsylvania revealed to his parents he was having a sexual relationship with the middle school guidance counselor. Now she faces multiple charges and is on administrative leave. Trial attorney and former prosecutor Florina Altshiler joins us to talk about the case. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. I was going to say I can't believe what I'm about to talk to you about, but given the stories we have been covering, I guess I'm really not that surprised. Another female school employee is accused of sex-related crimes. Yeah. This time, a Pennsylvania woman contacted police in Pennsburg over the summer saying that her 14-year-old son was involved in a romantic and sexual relationship with Ann Schutte. Schutte is a 35-year-old guidance counselor at Penridge South Middle School, or I should say she was. Right now, Schutte is charged with 3 counts of institutional sexual assault, 3 counts of indecent assault of a person less than 16 years old, and 1 count of corruption of a minor. According to the police, the teen called his parents the night of July 17th, asking to be picked up from Schutte's home. And when the parents got there, he was reportedly hiding behind a parked car because he said that one of Schutte's family members had seen Schutte kissing the boy, demanded that he get out. The boy told police that he and Schutte had sexual contact multiple times. All happened after they sat together on a bus during a class trip. And what started as her regularly calling him to her office, even causing him to miss class, this turned physical. Police found both handwritten notes and electronic messages between Schutte and the boy, even on the school district's messaging app called Canvas. They apparently also communicated on Snapchat. Authorities also say that there's security footage showing Schutte and the teen inside of a grocery store where she bought a bottle of wine. She also allegedly left one of her earrings at the boy's home. Charges were filed against Schutte. She has been arraigned, and she posted a $25,000 bond. I want to bring in right now trial attorney and former prosecutor Florina Altshiler to talk more about this. Florina, my goodness, I mean, just another case. This one, though, we're going to get into it. I want to start with the charges because they're distinct. They seem like they overlap, but they're distinct in their own way, all relatively serious, all carry their own kind of very severe punishments in terms of how many years in prison we're talking about. But if you can generally describe to us or summarize, what do all these charges mean?
Sure. Thanks for having me, Jesse. So the first count, institutional sexual assault, is a felony in the 3rd degree in the state of Pennsylvania. That means that the possible sentencing range is up to a maximum of no more than 7 years. Then you also have the charge of indecent assault of a person less than 16 years. That charge is a misdemeanor in the 2nd degree in the state of Pennsylvania, and that has a maximum sentence range of up to 2 years in prison with a fine of $5,000. And then you have the charge of corruption of minors. Corruption of minors applies in 2 different ways. It sometimes applies to truancy, but here in this case, it's related to a sexual act. And because as charged, it's related to a sexual act in the state of Pennsylvania, you're also looking at a sentencing range of up to 7 years.
Okay, so we want to thank Morgan & Morgan for sponsoring this video. I think it's pretty clear from the stories that we cover that it's not always safe out there. And when you're hurt, it can be pretty confusing. It can be scary. You don't know where to turn. Well, Morgan & Morgan is actually the largest injury law firm in America. And at a time when you already have so much to think about, they make it super easy for you. They've completely modernized the process because you submit your claim, you sign contracts, you upload documents, and you talk to your whole legal team all on your phone. That's it. An attorney's going to review your case in just 8 clicks. Also, they have 4,000 support staff that can help you through the process too, which is just amazing to think about. And in terms of price, you only pay them if you win. There's no upfront fee. So if you're injured, you want to join the over 3 million people that call them every year, you can submit a claim at www.forthepeople.com/law&crime or by dialing #law, that's #529 on your phone. Just to be clear, any of these accounts, you take 1 count of sexual abuse, that could qualify as a crime under those 3 different statutes, or is it all separate kinds of incidents? You know, that's what I was trying to get a sense of, because I think indecent sexual assault is and I don't want to get too graphic here, but it's very specific in terms of what happened. And then institutional, the institutional sexual assault concerns the fact I assume that she was a guidance counselor at this school. So am I understanding it correctly that prosecutors would have to show, let's say, X, Y, and Z happened, one event happened, but it can qualify as a crime under these different statutes?
There's different elements to qualify for the different crimes. The institutional component, of course, requires the element that the defendant is an institutional actor. Here, she's a teacher, so that's what qualifies. For sentencing purposes, they could be consecutive or they could be concurrent. Running concurrent means running at the same time. If it's for the same act, so if it's the same one sexual act, it would run concurrent. So they wouldn't double up and add in time. They would all run at the same time if convicted. Right. If we're talking about different acts, so sexual activity maybe in different locations or at different points in time, then you're talking about separate counts for separate acts, which could run consecutive and add up.
Wow, that's something to think about. I mean, and this is happening in multiple counties, right? So according to CBS News, one sexual act occurred inside of her car near her home in Montgomery County on the same day that the boy later called his parents. And then another time, I think this is when the boy's parents and his sister were out of town. She allegedly engaged in some sort of sexual act with the boy at his home in Bucks County. A, talk to me about the fact that this is happening in different jurisdictions. And B, in your experience, is it common that you see this kind of abuse happening rather blatantly in these kind of public, I mean, not even public, but in these kinds of areas where, you know, it's not just at a schoolroom or a classroom, but it's at the people's homes. It's in their cars. It happens in these different areas. Is that what you typically see?
So different locations in different counties obviously give jurisdiction to different district attorney's offices to prosecute this. So she's being prosecuted in Bucks County, Pennsylvania right now for the acts that occurred there. The institutional portion would apply elsewhere because she's still an institutional actor as a teacher. Other jurisdictions would have jurisdiction over her based on the geographic location of where those acts happen. As to where they're happening and the variety of places, is there a good place to have sex with a child? Come on. No,
it's just, no, it's not that. It's what I was trying to say was, and I had this conversation with Chris Hansen on a previous sidebar, is what is amazing to me is how ongoing it occurs, right? It can occur over years. It can occur over months. It can occur over weeks, and it happens in various locations. And you're dealing with a minor who, you know, are under the custody of their parents. It's sometimes hard. It seems like a manipulation to get them away from their family to do this. And again, she's innocent until proven guilty. What is just some of the most shocking aspects of it are sometimes where they occur and how the perpetrator is able to get the minor alone. That's the part that always shocks me.
We're talking about a 15-year-old child here. So, you know,
14.
This isn't a 7-year-old that's difficult to get away from parents. Teenagers who are at that age will, you know, go to school, have after school activities, go out after school. Not too shocking that she's able to get this child away from his parents and have that be covered up for a period of time. Obviously, there's a period of grooming that goes on where the child becomes more comfortable with her. What isn't shocking, but is disturbing, what isn't surprising, I should say, is this is someone in a position of power. This is a teacher who has control over this child. And that, unfortunately, typically happens because they're in a unique position to groom students, to make these students be comfortable and to be able to cover up for contact that they have with them under the excuse of it somehow being school related. So they have extra access to children that other sexual deviants don't.
It's a great point. And that's, you know, one of the reasons allegedly calling him out of class to visit her at the office was just another element of it. I think this case feels different because of how much other evidence there is. The notes, the digital messages, there's surveillance footage, leaving behind, what was it? I said, you know, the earring leaving behind the earring. I mean, that feels different than we have in maybe other cases where the strongest piece of evidence, and you could argue the strongest piece of evidence would be the teen's own account, but sometimes that's all that you have. But to have all of this other evidence feels a little different, no?
Yeah, I think this is a case that's going to result in a plea deal. I don't see her fighting this through trial. I think there is overwhelming evidence that there was sexual contact between the two. And really, that's all that needs to be established. There is no question of consent because, again, we're talking about a child, and a child is not capable of consent. So the only question is whether or not there was sexual activity. And here, I think when you look at all this evidence cumulatively, the prosecution's going to be able to prove it beyond a reasonable doubt. So she should really seriously consider taking a plea. Someone without a criminal record, though, will get a very light plea deal in a case like this. So
You
we were
mean
talking earlier.
you mean no prison time?
Yeah, Jesse, we were talking earlier about these 7-year maximum sentences, and that sounds scary and significant. But the reality is, those 7-year maximum sentences are really for repeat offenders. She's not going to get a sentence like that. I've seen many cases with female teachers having sex with male child students, and they get probation, they get time served, they get less than a year in prison. Is that okay? I think that's a question for society to answer, but it's within the sentencing range.
You mentioned that when you have a female instructor or teacher or official with a male student, if it's reversed and you see a male teacher with a female minor, is that you see the same thing, these kinds of probation deals, or is it different?
I think it's a lot harder, and in my experience in criminal defense, it is a lot harder for me to get a favorable sentence for a male offender in a sex crime than it is for a female offender. And certainly the sentencing guidelines have no gender distinctions, but I think in the eyes of society, unfortunately, there is a gender distinction. There's not much sympathy for male victims as there is for female victims. And socially, there is this false presumption that I do not agree with, that a male child victim somehow wanted it, and that
Right.
this is some sort of pride badge, and that a female child, of course, could not have consented. And there is no difference on gender, in my opinion.
No,
It is
no,
strictly age-based.
you're 100% right. I mean, if she did this, this is abuse. He is a victim. And I've talked about this before on the program where, sometimes the trauma of that may not be apparent immediately, but it can have effects on that child for years to come, for the rest of their lives. And not even if it's just the idea of, like you said, there is no consent here. That's not a defense. They are a victim. And yes, I agree. The way that it's framed can be different. I think I'm surprised, to say the least, that this could be a possibility of just probation if she pleads guilty. So I want to ask you about the school district real quick, because the charges were filed now, but the school district said it was made aware of these allegations back in the summer. They put Schutte on administrative leave. Penridge Superintendent Angelo Berrio said in a release statement, quote, "We must acknowledge the significance of maintaining the privacy of the student and their family involved in this matter. While we refrain from making premature judgments about the actions of the staff member facing prosecution, it is crucial to reiterate the district's stance against any inappropriate contact between a Penridge School District employee and a student. Such behavior will not be tolerated." Is that concerning for you? Do you think that the school district could face liability by the fact that, they were made aware of this months before, but, maybe in a criminal investigation takes more time? I can't see anything that would indicate that they didn't take immediate action. But this this guidance counselor was employed there. Could the school district face any kind of liability?
Absolutely, they will face liability. I think there is a potential civil lawsuit for negligence, negligent supervision, negligent control, potentially even negligent hiring of this teacher. We don't know what is or isn't in her background and how thoroughly they investigated her in hiring her. But even assuming that that was fine, there's clearly negligent supervision because this is inappropriate sexual contact with a student that is under her control. And the school district has a duty to supervise its employees, including its teachers, to ensure that this type of sexual contact does not happen, especially during school hours, which is what puts the liability on them more significantly. If this was in evening hours outside of school, they would still have an issue about potentially her grooming him during her contact with him during school hours, which would pave the way for liability. But for sexual contact to happen also during school hours, that is highly problematic for the school district and will likely result in some sort of money settlement.
Now, as for Schutte, I mentioned she's out on bond. She is currently restricted from entering the school district premises or having any contact with any of the students or the staff. And of course, the alleged victim can go nowhere near him, have no contact with him. Florina Altshiler, thank you so much for coming on, really breaking this down for us and giving us some more insight into these cases because, unfortunately, we keep covering them because they keep happening. So, Florina, thanks so much. Really appreciate it.
Thanks for having me.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. Please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.